All rise. The State of Kansas Court of Appeals is now in session with the Honorable Amy Fellows Klein presiding.
Good morning. Please be seated. How's everybody doing today? Good, good. Happy to see you here. As I mentioned earlier when I came in and told everybody hi, we've got one case on the docket today, which is 126-026, Strategic Energy Income versus Stevens Energy et al. I am joined by two judges I'll introduce. I'm sure you're familiar with all of us, but I will introduce Gordon Atchison, who's been on our court for more than 20 years, and Judge Rachel Pickering, who joined us a few years ago, just right after I did, and Amy Klein. And we're happy and excited to dive right into the proceedings today. Everybody's ready.
It may seem like 20 years to some people. It's really more like 13.
Whenever you're ready to proceed, we'll have the parties introduce themselves.
Can I proceed, Your Honor? Mike Perry for the plaintiff appellant Strategic Energy Income Fund. Jason Dunn for the plaintiff appellant.
And who's going to be arguing today?
I will, Your Honor.
Okay.
And if I may, can I reserve 5 minutes of my time for rebuttal?
Absolutely. One thing I did want to address is there's a cross appeal. And so I'm not sure if you all had thoughts in particular on how you wanted to handle that, if you want to incorporate that into your arguments, or if you want to have some separate, if you want to deal with that separately. Have you had a conversation amongst yourselves about that?
Your Honor, Matt Salzman, representing Stevens Energy Group, one of the defendants. We're fine just incorporating it within, and we can just handle it, our affirmative argument of that, and we will not reserve time for rebuttal on that. So we can just.
Okay, and are you comfortable with that as well?
That's totally fine, and I think efficient.
Okay, sounds good. So you've got your 5 minutes reserved. And as I mentioned, you all are the only one on the docket, so we may be a little generous with time because it is a very fact-intensive case, but we will make sure that we give both sides equal time.
Jim Armstrong, I represent two of the appellees, Slauson Exploration and Alameda.
My name is Matt Salzman, and I represent Stevens Energy Group again. And here with me is David Bankston.
Are you guys going to divide your argument?
If it would please the court, if be allowed, we would like to just split it half and half.
Okay.
Arguing different issues.
Okay. Yeah, just as long as you don't do it like sentence by sentence or something.
We ham and egg. That might be a little much for even us.
So you're each.
And if I may, Your Honor, also on behalf of the appellant is Socorro Adams Dooley.
All right, we're ready when you are.
We got you up close and personal today, don't we? All right.
Thank you, Your Honors. It's a pleasure being here today. May it please the court, as indicated, I'm Mike Perry, and I'm here on behalf of the appellant Strategic Energy Income Fund. We, I think as the court noted, this is a fact-intensive case. It's been around for some time, and we're looking for resolution, and as well as part of that, looking for our day in court. And we're here today on appeal, raising 6 issues, as I think the court is aware. 2 issues relate to summary judgment rulings that the lower court granted on behalf of the defendants, and I'll speak a little bit about each of those. One has to do with a core agreement, the gas gathering agreement. The other summary judgment issue that Judge Comer granted summary judgment on behalf of the defendants is what we referred to as the damages ruling. Then last, the 5th and 6th issues that we have on appeal are the court's granting of 2 different motions to dismiss some years ago relating to a variety of different tort claims. Besides those claims more on the merits, the other two issues that we are here and would like to speak a little bit about are an order entered by the district court denying the plaintiff appellant's efforts at amending the pretrial order, where we attempted to conform the claims to the evidence that had been developed over the course of discovery. And then finally, the issue that we're seeking relief on is the lower court's ruling striking the plaintiff's demand for a jury trial, recognizing jury issues did not exist across the board, but we believed jury claims exist with respect to a number of the claims.
Before you get really rolling here, this is a somewhat sprawling case from my perspective. Could you explain how the gas gathering agreement sort of integrates with the other claims and why it's real important to you that we find that there was in fact an agreement when the district court said there was not? I mean, how does that fit in with the rest of what you're arguing?
I appreciate that, Your Honor. That's a core issue.
Well, I understand it, but why is it?
Yes, because it's somewhat self-evident here, and I think the record's clear on this, that when this particular asset, a pipeline system, a gas gathering system that was created by these parties to move gas from a field in Oklahoma that Slauson originally planned to develop, you have to move that gas in some fashion, and there wasn't capacity, so you needed a pipeline. And for that pipeline to work, the way you evidence and document the movement of gas is through a gas gathering agreement. You have the owners of the gas, the hydrocarbons, then you have what's referred to as a shipper, and then you have the operator of the pipeline. And to create value for that pipeline, you have to have what the industry refers to as throughput. And that's nothing more than, in layman's terms, the gas moving through the pipeline. And without having that supply dedicated to the pipeline, what value do you have in the system?
Okay, so I mean, I didn't mean to interrupt. Well, I do
You're fine.
interrupt you, but so I mean, the value here from your perspective is that there was this 10-year commitment to do that, and that made the pipeline company itself valuable.
Have value, absolutely.
Okay, and without that, it's not valuable.
And you're spot on, Your Honor. They go hand in hand, and anyone in the industry would recognize that. The more throughput you have in a system, that's guaranteed, meaning someone can look, if someone's going to buy that, hey, here's a revenue stream. It's no different than a landlord in a commercial building. The more tenants you have, the higher your income stream's going to be.
Can you explain the interplay between the gas gathering agreement and that NAESB form agreement, how they work together? Because I understand in your brief, you seem to refer to them collectively as a original dedication, but they're actually two separate agreements, correct?
Yes, Your Honor. Great question. And that was set up by Slauson originally. They're the ones that linked the two. They created the structure. They could have, Slauson, when they originally did this deal, had an agreement directly with Nemaha Gas, the pipeline system themselves. But I think the record shows the reason they didn't want to do that is because they operated the pipeline system and they also were the owner of the hydrocarbons. And they wanted to put in an intermediary to create some flexibility in dealing with royalty owners. And so what the structure they put in place was And that, if I may say, the NASB for short, you picked up on it correctly, the NAESB contract, and that's an industry term. Slauson set it up where they had a 10-year agreement with EFP, Energy, Financial, and Physical,
NASB.
in the NASB.
Right.
And then so the chain of custody, if you will, would go from Slauson to EFP to the pipeline, Nemaha Gas, which Slauson was the operator of. You have no value to the pipeline without that linkage between Slauson EFP and then EFP to Nemaha Gas. They go hand in hand. On the flip side of that, where did the gas go? To the enables a big intrastate pipeline in Oklahoma.
Well, I mean, I got all that. I mean, but getting back to, I mean, this lawsuit, what is essentially the unlawful conduct that has wronged your client if there is no gas gathering agreement?
Well,
I mean, what's the wrongful conduct you're suing on there?
fair. Well, to close the loop on something, there is the linkage between the NASB and the gas gathering agreement, because that created the firm 10-year commitment supply to the gathering system. What the harm was, what the bad act was, what triggered this whole lawsuit was Slauson and Stevens getting together on the eve of our closing, Strategic's closing, literally the day before their ROFR rights to acquire, ultimately, they'd own 100% of the gathering system. Literally the day before, Slauson and Stevens directs Slauson to cancel the NASB agreement. And they did. And they knew they shouldn't have. They knew that was going to create harm, because they got, and this is all in the record, they required Stevens, Slauson did, to indemnify them for that action. They knew they shouldn't have done that, and then they got sued over it.
But I thought they canceled the NASB because there were some issues with the substance, with the form of the contract, that it was not the proper industry form for this application. And there were some business reasons for canceling it. Am I misunderstanding that?
I think that would be the pretext under which Stevens said they did it, but they had no lawful right to have that done. It was a binding 10-year agreement.
Wasn't it also terminable within 30 days notice?
Not after, no, Your Honor, it was not.
The NASB was not?
No, they had to, there was a transaction confirmation entered April 1 of 2013, if I have my dates right, that made it a 10-year deal. When it was originally set up in 2012, it was I believe, a 1-year term, but they amended that agreement through a transaction confirmation in 2013, all tied to the 10-year commitment that Enable required.
Was there anything stopping your client from executing a new NASB? Like, you could have executed your right of first refusal, completed the purchase, and then entered your own 10-year dedication with Enable. Was there anything stopping you from doing that?
Our agreement was to market the gas through Slauson under the joint operating agreement. And when I say it wasn't Strategic, Strategic did not own the oil and gas interests. Strategic just owned the membership interest in the LLC that owned the pipeline. U.S. Energy had, who's the general partner of Strategic, they're the ones who owned the lease operating rights. And they had an agreement with Slauson through the JOA to market their gas through Slauson, which is very ordinary in the industry. That's a common.
Let me go back to my original question, because I'm not sure, I'm not understanding.
Okay.
So why is it important, and why is it an issue on appeal about the quote unsigned gas gathering agreement. That's what you're arguing about, is the judge got that wrong.
Correct,
That is a binding contract.
correct.
Okay, and it's separate from the NASB.
The NASB, correct.
Okay, so, but why is the unsigned gas gathering agreement so important, and why do you need it? I mean, how does the judge's ruling on that affect the claim here? I mean, we haven't even really talked about that.
And I appreciate that. Okay. So if we're tracking on the NASB, the gas goes contractually from Slauson through EFP
Right.
under the NASB. Then it goes from EFP to Nemaha Gas through the gas gathering agreement. So you have those two contracts, both of which need to be in effect in order to have the 10-year supply or dedication.
And for the pipeline company to have any value.
To have
And that's
value.
what you guys had the right of refusal for, and you're claiming the value of it tanked when they torpedoed this agreement. That's your theory. Right?
Exactly that.
All right.
And so there's two pieces to that. If either one of those legs get cut out, meaning when the NASB got terminated, that separated there being a dedicated gas supply. So that created harm. And that was the bad act implemented under our theory of the case against the defendants. In terms of the issue on appeal, Your Honor, and the gas gathering agreement, if by virtue of the lower court deciding that's not a binding enforceable agreement, then we're back to, that's the second prong of the dedication that's undermined and cuts out value from the pipeline.
What's your strongest argument that it was an enforceable agreement? I'm looking at your brief and you presented a few arguments, but what is your strongest argument?
Okay, so the judge, thank you, Your Honor. The judge ruled that it's not signed and therefore it's not enforceable. And I think the parties agree on this. This issue is decided under Oklahoma law and the statute of frauds under Oklahoma law. And you have to.
I was going to get to that eventually. Is that correct, though? I mean, Kansas is a lex loci contractus state. So the issue of contract formation is decided by Kansas law, isn't it?
In our view, it was decided under Oklahoma law.
Well, I mean, I understand it was decided under local, but should it have been is my question, and why?
Well, no one, to my knowledge, in the case ever disputed that. So I don't know that, and I'm not going to sit here and say you're wrong or it's not.
It gets to a related question, and I mean, obviously, we're going to go over the time on this because there's a lot of stuff going on.
I still want an answer to the question I had.
Yes, yeah, we'll come back.
We'll get you there. We're not going to pull you too many far away from your argument.
Okay, so under Oklahoma law, to satisfy the statute of frauds, it's not fatal that we don't have that signed agreement. You have to have some memorandum in some fashion that the law recognizes as indicating that the parties to that agreement gave their assent to it. And we have a laundry list, and I'll give you the core ones, Your Honor. In the response to that motion that plaintiffs or that the defendants filed, we had a statement of additional material facts that we incorporated, and there were 29 facts that were incorporated. And there's a laundry list, and I'll give you you want our best ones? Here's our best ones. On July 4, 2014, Stu Kowalski, who is the in-house counsel for Slauson and Alameda, emailed Lee Dawkins, who is the in-house counsel for Stevens. And in that email on July 4, 2014, Mr. Kowalski emails Mr. Dawkins and attaches the gas gathering agreement that the parties had been operating under for over a year and wrote, both EFP and Nemaha are prepared to sign this agreement. There, Mr. Kowalski is, the only reasonable reading of that is Mr. Kowalski telling Mr. Dawkins of Stevens, the parties have agreed to these terms and they are prepared to sign it.
But he's not saying Slauson's prepared to sign it.
Slauson and Alameda, and that's part of our theory of the case, are alter egos of each other. And I don't know if that's where Your Honor was going, but he's indicating the assent to the parties to that agreement that they're ready to sign. It's both EFP and Nemaha, and those are the parties to the agreement. And Slauson was the operator of Nemaha. So when Mr. Kowalski is speaking about that, he's speaking on behalf of Slauson.
And this is why you wanted to add your alter ego claim later on.
Correct.
That's order.
That's part of it. Yes, Your Honor.
This is a party admission.
Correct. That's July 4, 2014, and that's in the record, Judge Pickering. The next point that I point out in support of overcoming the unsigned gas gathering agreement is what occurred on or about August 8, 2014, when the MIPA, the Membership Interest Purchase Agreement, was executed. And that was by Alameda and MBI, who owned the 56% membership interest that was going to be sold to Stevens. And why is that significant? The execution of the MIPA. Well, an examination of what the MIPA provides, which is a signed document, is several things. When we examine, and I'll direct the court to where they can find this. In section 4.18 of the MIPA, there's a section called contracts. There's both a textual section denominated 4.18. There's also a corresponding schedule or an appendix attached that's schedule 4.18. And in the textual portion, and I think this is key, Your Honor, the language says verbatim, except for contracts and agreements listed or described in Schedule 4.18 attached here too, Nemaha is not a party to or bound by any material, written, or oral contract or agreement whatsoever. In other words, except for those described in Schedule 4.18, there's not another agreement that Nemaha is a party to or bound by. The clear reading of that is the agreements that are in Schedule 4.18 are the agreements that Nemaha is a party to and bound by. That's what that says.
Well, you're inferring the inverse from the language.
Error. But I don't know any other reasonable way to read that. Why would you say it that way? That's the, and on summary judgment, the goal of, or the duty of the trial court is to give all reasonable inferences to the party opposing summary judgment. Moreover, when you go to the schedule 4.18, the first listed agreement that's denominated as a material contract is this unsigned gas gathering agreement. Why would you, and I'd ask the court, I'd ask the jury, why would you have an agreement listed as a material contract if it's not an agreement that the parties are subject to or bound by?
Well, I understand your friend on the other side to argue that, I mean, they use material in terms of this is an important contract that we are negotiating. It's out there in the ether. We felt obligated to disclose it to you. And that's my understanding of their argument as to why it's included, that they felt they had a duty to notify the parties that this is out there. What's your response to that argument?
Why would there be a duty to disclose something if the parties weren't bound by it?
Well, because they've been negotiating, because it's still not signed yet, wouldn't it be important to know, like, it's not signed, it's not fully executed, but we have been talking about this, there is this piece of the puzzle that should be considered?
Well, a couple of things. One, if it's not binding, why would it matter to a party? If it's of no force or effect, you could list any number of things that they've talked about, but it has no force or effect. So why would anyone truly care? Particularly if some third party is coming in, like in this case, the ROFR, why would you care if something's not a binding agreement?
Well, I thought it was integral that there be an agreement that covers that.
Well, but that goes to our point. It is a binding material agreement. That our view of the world is that it was an enforceable
Well,
agreement.
I don't know, I didn't do this stuff when I was in practice. I didn't negotiate, I was a litigator, but it seems to me if there's something listed as a material contract and it's listed as an unsigned agreement, isn't that some kind of red flag that there's an issue there? I mean, it's like unsigned. Well, okay, what is that? Why are you listing this thing that's unsigned as material? And what does that mean? Is there some due diligence there to inquire?
In a vacuum, I think that's fair. I don't know that I disagree with you, but in the context of the record here
Okay.
and in the history that had taken place and the representation, our client, the strategic, was told on multiple occasions, there's no issue. We have an agreement. And the parties performed under it for over a year. The only reason it was never signed at the end of the day is because Stevens told them, who wasn't even a party to it, to not sign it. I mean, so in the context of the circumstances here and the record made, I think it takes it away from the view you were looking at it, Your Honor.
Let me jump into this silent pause here and get back to my choice of law.
Yes.
And I really was more curious about the choice of law issue with respect to the torts and New York state law applying. And I mean, I understand that it's in the pretrial order and the parties reference that, but why is that the controlling law? I mean, what legal doctrine makes that the controlling law?
But because at that point in time, and forgive me, Your Honor, because I didn't necessarily go back to that because that wasn't an issue that the parties had ever disagreed on. But as I recall, the aggrieved party, in this case, strategic, they were a resident of New York, and under the choice of law rules that were applicable, New York applied is what drove that.
What,
And
what choice of law rule you're referring to?
well, in terms of figuring out,
I mean, I'm puzzled by that. It just sort of appears in the pretrial order, like you all agreed that New York law applies. I mean, could you have agreed that Montana law applies and we're bound?
oh, no, I don't know the answer to that, but I know back at that time, and that was some time ago,
Yeah.
that all the parties looked at it and came to an understanding that that's the right conclusion.
Are we bound by that? If it's not correct, I mean, I don't know whether it is, I mean, it's puzzling to me. Cause I mean, you're talking about torts, they're unusual torts in the sense like a personal injury or a malpractice case. But I mean, Kansas looks at the situs of the injury as the control by choice of law. And I'm not sure how New York is the situs of an injury here.
Well, it's because that's where strategic was based.
Okay,
They're no longer based there. They've moved to Texas, but at the time of the alleged harm, the aggrieved parties were residents of New York. And that's my recollection.
I'm not sure it matters. It leaped out at me and there's obviously a whole bunch of interesting New York laws. I mean, I'm not sure we're disadvantaged here, but it struck me as slightly peculiar.
Well, and I'm not sure that would have been my choice that it be New York, but I think all reasonably concluded
Okay,
that for the tort claims, that was the law that we needed to consider.
all right.
I have a question about the interplay amongst all the different claims. I understand that Stevens claim, if we affirm the partial summary judgment decision on damages, that moots all the other appellate issues. Do you agree with that?
As much as I would like to disagree with that, I think that's the only reasonable conclusion
I
to come
appreciate your
to.
candor.
Yes.
I'm not sure. I mean, I was going to ask your other side, other parties about that. That doesn't dispose of the $500,000 earnest money, or is that just chump change that we're not concerned about? I mean, the tort claims and stuff are all the millions of dollars of the lost business opportunity.
Correct.
You still got $500,000 in earnest money you want back. You don't need an expert on damages for that, right?
True, that's
Well,
fair.
are you conceding that that's not?
No,
I wasn't precise in my
The candle
Well,
for that?
question. Are we just talking about the issues on appeal, that maybe the case is still going on below, but in terms of the issues on appeal, is our decision?
well, and forgive me, because Judge Atchison raised a good point. I don't.
I try hard occasionally.
On the court 20 years.
Terms of the issues that we were here, that I understood us to be here about today, I think the damages, if this court affirmed that ruling, the claims we were otherwise asserting,
On appeal.
on appeal, we believe in liability, but if there's no damages, there's,
Well,
that.
but, all right. So
If
we affirm on that, on the damages ruling, you're saying the case is over.
well, would strategic like their $500,000 back? Yes.
Well, I made a claim for it.
Yes.
Okay, but the damages thing is all about the expert and potential problems with his.
Correct.
All right, so if we decide that and the expert isn't any good and he's out, you still have your claim for the $500,000. Well, I'm trying, and you're saying, well, it disposes of the case, but it doesn't
Well,
really, does it?
and I was focused on Judge Klein, and you, and the issues implicated by what I understood her question to be.
Okay, well, I didn't like this question.
Too. And I could be more precise,
But-
in terms of the issues on appeal.
I like all of your
If
questions.
we affirm on the damages issue, do we need to decide whether the judge's decision to strike the jury trial demand, do we need to decide that issue?
I'm gonna say yes.
We still need to decide what are you gonna get a jury trial on? Your accounting claim below? Your declaratory judgment?
Our 500,000.
And so that's the remedy, but what's the vehicle to get to that remedy? I thought that was the accounting claim.
No, that's, we didn't close, and, that was a down payment on the closing on the membership interest. Now,
So what's the claim to get recovery of that amount of money?
It's contract based.
And it's a restitution award, right? But that's an equitable one. You don't get a jury.
Well,
trial. But
to me, it's a contract claim under the agreement.
yeah, but I guess I want to make sure we're not getting off on some tangent here. That if we issued an opinion that says the judge was right on the damages expert, but wrong on some of the other stuff, I mean, there's still then something to litigate, and it's the $500,000, right? Or are you just saying, I mean, if you lose on the damages thing, you're gonna concede on the 500,000?
Well, I mean, there's to me some practical implications there too.
Well,
I mean,
I would think so going
yeah.
forward, but
Yeah.
that the practical implication of it isn't
You're
something we can write into the
correct.
opinion. All right, so I mean, if all we agreed with the district court on was the damages and the expert is out, there is a live piece of litigation left.
Well, my colleagues may disagree, but
I want to know your position. I mean, I understand theirs. I'm just trying to ferret out, for example, do we need to decide the issue on amending the pretrial order? If we would affirm on the damages, is amending the pretrial order still an issue? Because weren't those tort claims you were using to
y-
see that they weren't
yeah.
related to reimbursement
the-
of the,
I mean, I think the short answer to that question is it would moot the claims we were seeking to bring in under the motion for leave to amend.
and would it moot the dismissal of the fraud claim against Stevens and the dismissal of the aiding abetting claims?
Yes,
Okay.
the issues 5 and 6 those tort claims all related to the bad act in canceling the NASB back on September 17 of 2014. So that
And the damages flowing from that are what your expert.
correct.
Okay, so if the expert is out, that moves out 5 and 6.
And 4.
issues. Well, also, yeah, but,
Fair.
okay,
But you,
Now,
right,
well,
and then I'm just trying to, like I said, it's kind of a choose your own adventure. And so if, for example, I believe your friend on the other side also claims that if we affirmed the partial summary judgment decision on the validity of the gas gathering agreement, then we don't need to decide damages. Is that correct?
That would be fair.
And we don't need to decide 4, 5, and 6, or we don't need to decide 5 and 6, but we still need to decide 4.
That correct.
Okay.
Now, Judge Atchison, just so we're all on the same page. When you speak in terms of the expert or the strategics expert, Mr. Harden, I just want to be clear that the judge never ruled on a Daubert motion where his
Right, I got
testimony, okay. But in terms of his finding was we didn't establish a basis of the damages we were seeking.
But
So
they're
from
too
that,
speculative.
yeah,
right, and my question, I guess, I mean, was a hypothetical of assuming that we agreed with him on that, what is the impact on 5 and 6? I'm not saying that, obviously, we do agree with that.
right.
Okay,
But yeah, it would effectively moot the claims, the claims that are the subject matter of what we denominated as issues 5 and 6, because those were all different tort claims flowing from the bad act, the alleged bad act of canceling the dedication.
Canceling the NASB.
Yes.
Okay. And speaking of that, you use this term original dedication in your brief, and you say that it's defined as the gas gathering agreement, the NASB, and other related agreements. Can you tell me what those other related agreements are?
Yes, those are denominated, if you needed to find them in the record, in the response to our response to the motion for summary judgment on the gas gathering agreement. EFP had a number of I'm going to say associated agreements. I mean, there were about a dozen in total. And because EFP was the
marketer as well.
The marketer and administrator, and there's actually an entity that was created called Arrow, and Arrow was the administrator of for Nemaha Gas, but it was conducted through the people at EFP who Slauson brought in to manage all that. And they processed, and this goes to the issue of performance under the gas gathering agreement, that they had, the fees were established, and what fees are generated, the income stream, the value. There's transportation fees, there's compression fees. Those were all agreed to, and they're all set out in the unsigned gas gathering agreement. And all of those fees were paid to Nemaha Gas month after month after month.
How were well connection costs handled during the time the agreement was being negotiated? Because it's my understanding that that's what Stevens is saying was a term that was not finalized.
Correct. That is a contention. That's something that Stevens wanted to change, and they could have easily amended. I don't recall off the top of my head the pricing mechanism, but in the record there.
I thought there were a couple of different options, and at one point Slauson had proposed something, and I think that was even what was attached to the email to Stevens. Maybe that includes Slauson's proposal for how well connection costs would be handled. But can you tell me how they were handled in that year that you're claiming the parties were performing?
Well, what I'm not remembering is the specific pricing that was associated with it, but there was a pricing mechanism and a costing for how that was done. And forgive me, off the top of my head, I don't recall. I can't quote it off the top of my head, but it is in the record, how that was done.
They're in the record.
I'd have to double check. My belief is it's in the record relating to the gas gathering agreement
You could always,
briefing.
you could always find that and tell us on rebuttal if you have a. chance
Okay.
to do it. I don't know if I don't want to take them, but I am interested in issue 3, but I don't know where we are in terms of questions before I go to that. So this non-party, the district court on your brief, issue
Yeah.
3, you say district court erred in finding that Stevens, non-party to Nemaha gas operating agreement, can enforce a jury waiver under strategic. Now, I understand this case has already gone up in front of the Kansas Supreme Court. Is that correct?
Correct.
Okay.
On a writ.
On a writ. So we're gonna put that to the side. Okay,
Okay.
just for a second. Why is Stevens saying they have a right to enforce your client's jury trial waiver when they're not a signing party to the agreement? Can you please explain that to me? Because we're looking at a jury trial waiver, not any other minor agreement term. Would you-
Correct.
Okay,
And-
could you explain that to me,
and-
why they say they can impose themselves in that agreement?
Well, in full candor, it makes no sense to me. They're a non-party. They can't, what right do they have under an agreement that they, at the time these claims arose, they weren't a party to, and we never, Strategic, when they signed the operating agreement, that governs the operations of Nemaha Gas, that's where the two jury waiver provisions are. Just looking at the language, there's nothing in our view in that language that would import a waiver or extend a waiver to anyone that's not a party to that agreement.
And their argument is what? What puts them in that place? What was their argument? What did they say they had? How did they label Stevens?
Well, a couple of things, I think, although I'll totally candid, it doesn't make sense to me, but a couple of things would be, they read the language, and I think Judge Comer adopted it, that the language itself would extend to parties not under the agreement, that the language of the agreement itself was so broad that it would capture successors and non-parties.
Is there
But-
still an issue as to whether Stevens is a successor in interest to Alameda and MBI's interest under the operating agreement?
as we sit here today, during the point in time that all this was going on, Strategic opposed their, well, for over a year, they were never a party, even when they closed and acquired the 56% membership interest from MBI in Alameda. Strategic still challenged that transfer of interest for years. But at some point in time, in an
Dismiss those claims of.
yes, and Strategic no longer attempted to close, and I can't give a date because I don't know off the top of my head when that happened, but at some point in time, they would have come under the agreement.
So why does that not settle the issue of the applicability or enforceability of the jury trial waiver?
Um,
If they became successors in interest to the parties to the operating agreement, couldn't they step into their shoes and enforce that jury trial waiver?
at the point in time, to me, my answer to that's going to be no, Your Honor, because what you look, to me, what you look at as is the point in time that the damages and the harm occurred, and the acts giving rise to the claim, and they were nowhere close to being a party at that point in time.
But no one was asking for a jury trial at that time.
Well, at the point in time we sued, yes, and they weren't a party.
Because you claim that you were disputing their position as successor in interest
Correct.
at the time you filed the lawsuit.
Correct.
So you're kind of capturing that time, and because you were disputing it, you're claiming that dispute is enough to prevent them from enforcing that part of the contract?
Yeah, because we challenged their standing as a member under the agreement.
And what
Does
was the
that make
basis of
sense?
that challenge?
That it was they're wrong, that they acquired the interest lawfully. We had a claim that and it was part of the fraud claim against them, that they represented they weren't going to close. When we, I mean, it's in the record.
Right.
Representatives of US Energy contacted them a year after the fact, and because there was sort of a stalemate and where's this going to go? And the US Energy representative, who's no longer with us, meaning he has passed, had a conversation, and the Stevens representatives told them, yes, Mr. Walsh, Doug Walsh, we're not planning on closing. We agree with you. If you don't close, we're not going to close either. And Mr. Walsh and Strategic relied on that representation to say, you know what, we're going to tell Slauson that we're not going to close now, with an understanding there'd be no closing.
I want to circle back to my question.
Yes, I'm sorry.
And no, you're doing a great job, because we're taking you to, we all have, that's what you get with panel 3 judges. Everybody has.
And I
questions.
appreciate that.
The reason why I asked you that question about what is the basis of Stephen as a non-party saying they can enforce the jury trial waiver is they're saying we are a successor in interest, right? They're saying that we came into the agreement. That's their argument, correct?
At
It's-
the time, I don't think that would have
Right,
been the
but
case, but
that's still their argument, correct? Now, if you were to come into an agreement, does that change your competitive role with Strategic? In other words, I then move forward to the last issues on 6 and 7 regarding the fraud, misrepresentation, and the district court said, you, Strategic, had no right to rely on what Stevens was saying. They're your competitor. And yet Stevens is trying to insert themselves as a party now to the jury trial waiver. So in my mind, when I read these issues all together, I'm wondering, is Stevens putting a different label on its hat with respect to each issue, or are they same? And I will be asking opposing counsel that same question.
Well, and I see where you're going, and I would tend to agree with you. I'd further add on the whole competitor issue, our strategic's view at the time was they were not a competitor to begin with. They were, I mean, now I'm bringing into the equation US Energy. US Energy and Stevens were partners under the joint operating agreement and participation agreement. And the bigger dollar asset, if you will, were the leasehold interests. And from strategic and Mr. Walsh's perspective, hey, we're business partners here. We're not competitors.
Right,
But-
that's
but-
why I was
but-
trying to understand.
But
When are they competitors and when are they part of the agreement, which allows them to say, you cannot,
well, sometimes there does seem to be a sense of, uh, and no disrespect to the other table at all, but parties will say things at times that are convenient for the purpose at hand, and it may not be so convenient. Now, if I may just use as another example, the whole issue on damages of whether they were a willing buyer. They like to say they're a willing buyer, but on one side of the mouth, but on the other hand, we had no interest in the pipeline. How can both of those things apply? And to your honor's point, I mean, I would tend to agree with you on, well, I'm going to back up first. I'm not convinced that the fact that they were a competitor, even if that was the right conclusion, our view is that's not the right conclusion, that they're a competitor. But I mean, and I'm speaking of 5 and 6 now.
correct?
To me, under the circumstances that existed among the framework of the parties at the time, the lower court, and it was not Judge Comer at the time, took the view that, hey, if you're a competitor, you have no basis relying on what the other side says. But at that point in time, with respect to the membership interest purchase agreement and the Nemaha, the pipeline, even if Nemaha Gas, or excuse me, even if Strategic had been successful and closed and acquired all 100%, in our view, we still would have been business partners. Strategic would have been business partners with Stevens, because Stevens would have been moving gas on the pipeline. Even if they didn't own it, they're moving gas. You're not a competitor then, you're a business partner. You may not share a common interest, but you have a mutual interest in moving your gas jointly with US Energy on a facility that it's in your best interest to serve and to conduct business through. So with all of that, I don't understand the conclusion that they're a competitor. And then relatedly, as a matter of law, we would disagree with the contention that if you're a competitor, if you're dealing with a competitor, you have no basis to rely on anything they tell you.
So it was a factual question then of whether they were a competitor or not when the judge made the ruling that.
Correct.
And that adds to your argument.
Correct.
I have some questions about the damages claim.
Yes, ma'am.
And some of them relate to facts that I understand the court found were not controverted and based its decision on. And I just want to be clear because I'm not sure what your position is. I understand that one of your issues with the district court's conclusion on damages is you felt like the basis was incorrect because it was the court incorrectly found that your expert based his opinion in part on a 2012 volume of gas prediction that Slauson had put out in the beginning when they were trying to justify building the pipeline. Do I understand your argument correctly?
And I'm sorry, do you mind repeating that?
That you say the court incorrectly found that part of the reason Hardin's damages that Hardin relied on or relied on Slauson's 2012 volume of gas prediction, that you're saying the court improperly found that. Is that correct?
That is correct. Yes, that was not the basis upon Mr. Hardin's analysis. That, and I mean, the
No.
record's clear. I mean,
I understand that, but my confusion is in your reply
mhm.
or in your response to the motion for summary judgment on damages, you cited additional material facts, and your very first additional material fact was, oh, hey, by the way, Slauson projected all this gas volume back in 2012. And it seemed like you were citing that information to say, look, it's in line with our damage projection. And that's where the court made that logical leap. And I'm trying to figure out, what is the purpose of you putting that information in your additional material fact if it was not to support Hardin's damage projection?
I follow, Your Honor. I'm sorry.
We're taking you quite a while.
I thought it was all. And there were a couple of things that we had in there going back to 2012 when the parties started developing the Nemaha Ridge project area. Because at that point in time, there was a belief that was a really hot prospect, and there was lots of drilling going on in Oklahoma. And this is all in the record, but
Right.
through virtually the end of 2014, I mean, think from 2012 through 13 through 2014, things got in the industry got progressively better. There was more development, and Slauson had big plans to drill. That's why they added the conceived and put in the gathering system in the first place, because of this projection. There's all this acreage out here that we own that we're going to develop.
Before they started drilling, we had
Before
this
they
projection.
started drilling. So what transpired and or what continued to be projected was all consistent. It is the only point of that. But Mr. Hardin did not rely on that. Yes, did we add that in the record to show the consistency of what operators had projected in that prospect area? Yes, but that's that's a fair question. Why we took exception with the judge's statement about it is because that's not what Mr. Hardin relied on.
He relied on, was it the Whitmer US Energy model, correct? That's what Hardin relied on.
Coupled with the projected drilling, yes, that was a big piece of it, no question. Coupled with the projected drilling schedule, meaning the number of rigs that Stevens had shared that they planned on utilizing at different points in time. And the more rigs you run, the more wells you're going to drill.
And that information was shared in a phone call that Mr. Whitmer was involved in, correct? I think it was his affidavit where
Yes.
he said, this is where I got the rig drilling information.
Yes.
And I thought Whitmer used that phone call comment to create his model, which is what then Hardin relied on. Is that correct?
On one hand, I'd say that's probably somewhat of a generalization, but it's not wrong. That's fair.
Well, did Hardin have independent information about a drilling rig schedule that Stevens had planned?
Well, what he had information on is what was going on in the industry and in the area with other operators and development that was going on in the area. And particularly there were two big plays going on. The
Mississippi and
And the Woodford.
And the
yes.
Woodford is the one that Strategic placed no value on, or excuse me, Stevens placed no
Correct.
value on, but Strategic felt like there was some value.
Correct, that's fair.
How long does it take to drill and complete a well in the Woodford Shale?
Um, well, it changes over time, but.
Back
but
then,
back
when we're
then-
looking at a drilling rig schedule, that's different than looking at the number of wells, correct?
Correct,
And
correct.
so how long would it take for each rig to drill and complete a well?
60 to 90 days.
And so how are we translating the drilling rig schedule from a phone conversation into the number of wells that you felt the operator was going to drill?
And that's all laid out in the testimony. It's in the statement of undisputed facts, but it's based on the number of leasehold acres that the joint participants controlled. And I believe they had identified 70 units, and the multiple plays in each unit, and staged over time, and doing a discount was provided, because it's not like everyone necessarily going to be successful. But what was utilized was consistent with what operators in the area had
Off
used.
with the offset
Yes.
operators were using for spacing. And that was like, once again, that was Whitmer and US Energy, their calculations, correct? I mean,
Correct.
Hardin didn't go independently look at the productivity of, or examine the productivity of the Woodford Shale. He didn't go look at offset operator spacing. He relied on US Energy to give him that information. Is that correct?
In terms of that the number, the 320, that would have come, no question, from US Energy. But in terms of what was going on in the area and what other producers were doing, I'm not going to say Mr. Hardin didn't look at that. That was part of his analysis. He didn't do it in a vacuum.
And do you dispute that Hardin, I understand Hardin testified in his deposition that he didn't look at Stephen, the operator model. Is that correct?
I think that would be fair. But but to be clear, there was a point in time US Energy was the operator, and as a co-owner of interest in that area, US Energy has the right to propose wells.
But he didn't look at Stevens' plans for
Cor-
drilling.
Correct.
When we say operator, the only operator would have been US Energy. The only operator that Hardin would have looked at their plans would have
Okay,
been US
fair,
Energy
fair.
plan, never Stevens. What, tell me in your brief if you responded to this, I may have missed it. I understand the court, I think the district court judge gave 4 or 5 different reasons for finding the Hardin's damage estimate too speculative, or I think the court used the word surreal. And in one of those findings, what related to kind of the timing of everything, where the court mentioned, look at in September of 14, you didn't have a buyer for your flip sale. They extended the time for you to try to go find a buyer. And then in the meantime, we've got this market depression. And now we've got, a massive devaluation of these assets. And then there's an issue as to whether, Stevens even wants to buy them anymore based on that. And in my understanding, the district court said, look, Hardin didn't take that into account. Hardin didn't look at kind of the market and that depression that happened right around that time. What's your response to the district court's position on that point?
Okay, and this would be in our briefing, it's clear to us that damages are measured at the time of the harm, and the harm occurred in September of 14, before the change in market conditions that had depressed the market well into frankly the next several years after that. So in terms of the question of did Mr. Hardin look at it, I'd say 2 things. on one hand, he did look at it, he was aware of it, but under the law, that's not the point in time you assess the damage. So I'd say he looked at it, but he didn't consider it. It didn't cause him to change his evaluation because that's not the point in time that the damages occurred. That would
But
be the
in time in
distinction.
September of 14, you didn't have this flippy buyer, right?
No, no question about that, Your Honor. Would I love to be here and say, hey, here's a contract that we had with a third party with the ink on the dotted line? Would that be a stronger case? I'm confident it would be. And no one has ever said there that we had that. But does that make the claim fatal? We say no. Why? Because why did we not have that? What happened before we even closed? US Strategic started marketing this when they knew they had the MIPA was out there and they had their ROFR rights and they saw an opportunity. And they acted immediately on that opportunity and they started contacting industry participants, and anyone in the industry is going to know you have to have the dedication. And the day before we were scheduled to close, when Strategic was scheduled to close, they canceled the dedication that had been in effect. And at that point, how are you able to market it? A year later, they got it. I'm not going to sit here and say it was a binding offer, but a year later, an industry participant threw out 26 million, which is
This is
6
the Tall
million.
Oak.
Yes. Did that result? I mean, that was a year after the fact. Was that a binding final offer? No, I'm
But
not
what do
going
we
to.
do with Tall Oak's offer when, once they found out Stevens' drilling plan, didn't they reduce it from 26 to 12?
Correct.
And so how does that play into Hardin's evaluation? I mean, it's my understanding the district court said that's kind of another issue that Hardin should have taken into account, that when we have a real life buyer out there, when they got the information that Hardin didn't include, then they, reduced their offer.
Well, I'd say my response would be similar to what I said to one of your earlier questions. Mr. Hardin was aware of it, but did he take it into account? No, because the damages arose on September 17, not a year later when Tall Oak dropped their offer.
So it's your position that we need to look at the damages as of September 14?
Correct.
Okay.
Correct.
Anybody else?
I do have two
Oh,
quick
okay.
questions, but I wanted to make sure. You didn't have any more first, so. Okay. Two questions about the right of first refusal. Did Strategic, what did Strategic pay or in order to have that right of first refusal? Did they pay anything in terms of monetary value, or what kind of value did they give to have that right of first refusal?
Well, if I'm
General terms.
well, if I'm following, the right was provided among the owners as part of the agreement.
Okay.
And as part of the operating agreement. If Strategic had marketed, had decided they wanted to sell their interest, they would have the other owners, Alameda and MBI, would have had a right of first refusal. I'm not aware, and I'm not aware of there being separate consideration, like specific to just the ROFR right.
And then if a person has a right of first refusal, in this case Strategic, do they have the right to receive all the information necessary in order to make a decision to exercise that right?
Have the right under the operating agreement. Now, they weren't the
In other words, is there a duty amongst the other two parties to inform them, to provide them with all the information they need?
the short answer to that would be yes, and that's part of the basis of some of our claims
Correct.
of breach of fiduciary duty on either way you slice it, in terms of the canceling of the dedication on one hand, but if and I don't know if this is the appropriate time to get into the amendment piece, but the amendment, one of the issues in the amendment is, wait a minute, guys, we've operated all along as if there's been a dedication. But, and this came about after Mr. Kowalski was deposed in late September of 2021. When, and
Well, I know you're going over an hour, but, and I'll let you can
I
finish
thought I
that
was
point.
still at 14 minutes, but
And then
Wait till you
I-
get to rebuttal.
I told you I had two questions, but the parent entity for Almeida is Lawson, correct?
correct. Well, let me, the parent is Alameda.
Alameda is the parent of
Yes.
Lawson.
Yes.
Okay.
Okay. Am I done, or can I?
I don't have any other questions right now.
Yeah, I guess you still got your 5 minutes of rebuttal.
Should I sit down? Because I was going to say something about the amendment, but if my time is up.
The amendment to the
Your time was up like an hour, so
I appreciate it. Thank
Okay.
you.
thank you.
for your candor in all your answers. That's very helpful.
Your honors.
So I understand you gentlemen are splitting your time.
Sorry, Your Honor, and,
You get an hour and you get.
no idea how long you'd like me to talk.
Well, probably to run out of questions, I guess. It sort of depends on which issues you're addressing and which ones
Exactly.
Mr. Armstrong. So why don't you just get up there and
Why don't you
start
tell us
rolling?
Can you tell us which issues you're going to address?
To be somewhat brief and to the point, I guess.
Judge Pickering asked if.
Yeah,
if
which
you'll-
issues are you addressing again? That helps us so we don't ask you questions that your co-counsel
Absolutely.
will be addressing.
First and foremost, it's my understanding that I'm responsible for answering any question you have, and I will do my darndest.
Right. but-
Second, may it please the court, I would like to address the unsigned gathering agreement. I will probably speak on the cross appeal. I will try to address some of the issues that came up about that Judge Atchison raised on just in these questions, governing law, questions that Judge Klein and Judge Atchison brought up about the interrelation of all issues and how that plays out in some parts of the record below that you all don't have because they aren't part of this appeal, which will shed light on some of those questions. And I will reserve, I wasn't planning on even talking on issues 5 and 6.
Okay.
Resting on a brief on those, but I'm happy to answer any questions. I wasn't planning on really addressing jury waiver, but given Judge Pickering's questions, I'm going to start off right there.
Okay.
And then Mr. Armstrong will really delve into damages and the pretrial order amendments.
Hey, have at it.
May it please the court, I want to jump right into the jury waiver issue because there's some misconceptions there and I just want to be crystal clear.
Mhm.
Okay, one, with respect, we can't just set the Supreme Court's writ of mandamus order aside.
That was going to be my first
That's not the
question.
case.
That was going to be my first
It's
question.
done. We should be over. Sorry. And I know there's not Kansas governing law on that. Every other jurisdiction in the world that's
Well-
addressed it, treatises, I mean,
My understanding was that was essentially a minute order saying that it was denied without giving a reason.
right, so
Right.
it,
Well, and mandamus is an extraordinary writ. Could it not have then been denied because the Supreme Court in its infinite wisdom decided it wasn't appropriately brought as an extraordinary writ without getting to the merits at all?
if the Supreme Court did its job. Under
Well,
US Supreme Court
okay, but that's-
authority, I mean,
how
hypothetically,
do
they
you-
could have
well-
shirked their duties, but if they
How,
followed,
how would that be shirking their duties if they decided procedurally this is not the right vehicle and it's a not extraordinary remedy? I mean,
well,
I
okay,
get that. I think that would be
Fair
kind of
enough. fair enough.
squirrely, but you're wanting us to read something into a minute order that dismisses without a rationale when there is a very heightened standard to get a writ of mandamus. and wanting us to apply it to preclude the jury claim here where it's not the same standard.
So there are,
I mean, and I
US
understand the federal law. I mean, I read all that and it seems sort of sensible that that's the common vehicle that you would bring one of these. But without ruling on the merits, I don't understand how we can do what you want us to do based on a one sentence denial.
The only law that we were able to find on the issue from the US Supreme Court, not the Kansas Supreme Court, it's not governing or binding, so I can't represent that, indicates that when you have a situation like this with the jury, it's incumbent upon the court, one, that you're right, they say the mandamus is the proper vehicle to take that up, because it's a constitutional right, and you don't want to wait to appeal and then have to go back. So it takes into consideration, it gives them the benefit of the doubt by giving them an immediate vehicle.
Well, I understand
So-
that. I mean, I understand
Right,
the
so that's
theory
the
of
point.
it, but
Right? So step two,
yeah.
what is it supposed to do? Because there are writs of mandamus under other situations that are not given res judicata effect or law of the case effect. But if you dig deeper, the case law that has addressed this says it's incumbent upon, because of the constitutional right, because of the issue, it's incumbent upon the courts that are deciding that to decide on the merits. And it is determined that a denial, even a short one, even a one-liner, is given res judicata or law of the case implications.
Has the Kansas Supreme Court said that?
No, and that's
So-
why I'm
so
saying
you're-
this is all federal courts. And it frankly, it's consistent with every other jurisdiction in states that have addressed it. But to our knowledge, we did not find any Kansas Supreme Court or frankly, Kansas Court of Appeals decision directly addressing that issue. This court would be creating new law in the country to go a different way, but there is
That's
no
not the first
binding
time they've done that.
precedent that I'm aware of.
Could it also have been brought, and I didn't go research this, as a collateral order, an interlocutory appeal of a collateral order? Does collateral order doctrine allow that appeal?
Candidly, Judge Etson, I do not know the answer to that. All I can do is tell you that I do know that the writ of mandamus is deemed the proper procedure
Well,
even
in federal
in
court.
Kansas. No, even in
Really?
Kansas, I think there's stuff that says, so I think there's, now I'm out on a limb and I can hear it cracking behind me. I believe there's Kansas authority that says a writ of mandamus is a proper procedure,
Or a challenge, a denial of a jury?
a jury trial.
Okay.
But I believe that's I'm sorry, I could be mistaken and I can do a letter brief if the court wants further inquiry on this, but I believe that's as far as the Kansas authority goes. In other words, how the proper vehicle to challenge. I don't think there's any Kansas authority, to Judge Pickering's point, about what's the effect of that ruling.
Okay. I mean, I guess
But those cases that you talked about, those weren't just a simple denial, were they? Those were where the Supreme Court addressed the merits of the issue. Were there cases where they just said denied and therefore we as a court have to follow that? Based on
There
a
are.
simple ruling?
Yes, there are cases where there is one-line denials or very short, maybe paragraph, two-line denials, but all within one page that have been given res judicata and law of the case implications, depending upon whether it's in the same case or it addresses some other.
and
It-
those are the federal court decisions. Right. Okay.
Yes, no Kansas court that I'm aware of has ruled on the implication. But every court that I'm aware of that has so ruled, federal or other states, has ruled in favor with the treatises that we cite that say it's law of the case in this situation. So that's one issue that I was going to address on the jury waiver. I want to address another one. Read the cases carefully. Okay? Your concerns about whether a jury waiver can be applied, enforced with a non-party are at least half very exceptionally valid. Because they all say you cannot enforce a jury waiver against a non-party.
You can enforce a jury waiver against a party, even if you are not a party. Okay, let me repeat that. You cannot enforce it against a non-party because they didn't sign and agree to it. But you can, even if you're a non-party, enforce it against a party.
It
Now-
depends on the terms of the
Well,
waiver, though.
you said to
right?
read the cases carefully. You're relying on a Fourth Circuit case, correct? In that rule?
Primarily,
and Any
yes.
other circuits?
Yes,
The 10th Circuit, have they followed the same rule?
I don't believe their 10th Circuit has ruled on that issue. If they have, I wasn't able to
Okay,
find it.
I wanted to ask you about that. All right.
What about the argument of, Stevens becoming a successor and can enforce it there even though it's after the fact of the injury? That's
So there,
why is that a good argument?
may I get to that in a second? Heck, I'll do it now.
Yeah.
So-
Oral argument rule is.
Like appellate advocacy 101. man.
Hey, I blew it. I apologize. Let me get to that right now. So, in this case, that is an exceptionally good argument. And unfortunately, it's going to take me down another path to address something Judge Pickering brought up earlier. But it is an exceptionally good argument because counsel is correct. They had a claim challenging our ability to become a successor to the contract. Okay? They voluntarily dismissed it with prejudice, recognizing that we are a party to the contract. And guess what? We've been operating the pipeline ever since. We are the ones who are sending out financial statements. We are a member of the LLC.
So is there some time lag that you can't enforce the jury trial waiver because it involves something that happened before you became a successor and assigned?
They do not cite a single case that says that, nor have we found one in all candor. And yes, we did look. We
Okay,
did not find a single case that would support that. But I want to come back to the theory about why would a non-party, particularly in this situation. This jury waiver is contained in Namaha Pipeline Operating Agreement. Okay? That's the same document that contains the ROFR rights that started this whole thing. The document by its very nature contemplates reactions and involvement with third parties such as Stevens, who might offer to buy a membership interest. Yes, in a commercial adversarial relationship, and we'll get to what law governs and interesting questions, but this contract expressly envisions situations where the parties are going to be interacting with third parties on the very basis and foundation of this contract, the parts that it's supposed to govern between the parties.
But counsel, the problem I have with that theory is those third parties are not bargaining in exchanging consideration. And so when I look at the two parties to the contract, sometimes I'm going to agree to a term in one area of the contract because the other party to the contract is agreeing to something else. There's give and take between those parties to the contract. And so that's why we enforce the terms, because maybe, you know, you got some consideration for me and so did I in order to have this jury trial waiver. And then we have this third party come in who wasn't involved in any of that horse trading, who didn't put any consideration in to get the waiver, who wasn't involved in the bargaining. So how did they get the benefit of the bargaining that occurred between the two parties to the contract? Does that make sense?
Absolutely. So two answers. One, think of third-party beneficiaries, right? Happens all the time where people get to enforce a contract that there weren't original parties.
well, yeah, but doesn't the contract have to identify some specificity, the third party?
Did that agreement,
Depends, not necessarily, Your Honor.
I'm going
But-
way back.
But you can have this is not a third-party beneficiary
I don't think it
situation.
Right.
But it's an example, what I'm saying, that if you start with the premise that only parties to a contract can enforce the contract, it's a flawed premise, respectfully. Second, look
In
at,
that context of third party beneficiaries, right?
so
Which
look
we
at,
don't have here.
right, look at the plain language of the jury waiver provision. Okay, these parties who did do the contracting, who did do the horse trading and negotiating back and forth, could have easily said, This is enforceable by the parties to the contract. They didn't. They had two requirements, only two. One, you have, in order to waive the right, you have to be a party to the contract. Okay, and if they didn't have that, the law would really likely impose it anyway.
But by that logic, wouldn't you have to include that language in every term of the contract? I mean, it seems kind of redundant to say only the parties get to enforce section 1, only the parties get to enforce it. Section 2, only the parties get to enforce it. Isn't that kind of contemplated by the agreement?
I don't believe so, specifically not in this context where you have, I mean, a right of first refusal. When you have provisions like that, that invite others to be involved in the very nature of this, then it's not unheard of. You have litigation.
Who else are we inviting to get involved in the right of first refusal? I guess I perceive that as boxing other people out, that you're protecting the parties to the contract and their interest by saying we can box other people out by exercising our right of first refusal. You can't come in stranger and buy this interest because I'm going to exercise my right to keep you out.
But
How does the invitation flow the other way?
well, I would say that the very basis of the contract, it recognizes the existence of third parties dealing with the very core of the contract, the membership interest. And so if the parties wanted to say this right is limited to only the parties here, even though we know it's going to implicate other third parties on the core of the membership interest, they certainly, matter of contract, they could have said that, but here they did not. Going one step further to something Judge Pickering raised is an interrelation between this issue and the fraud issue. It is, I don't think it, well, first off, putting aside the governing law issue, it is crystal clear under New York law, which is the governing law for this tort of fraud, which I'll get to, that when parties are commercial adversaries under the governing New York law, they're not allowed to rely on each other's statements. The opposing party hasn't cited a single case indicating otherwise, nor have we found it. And we've given you two of the more precedent-setting ones, we believe, but there are others. There, by the very nature, when you have a right of first refusal, you have two parties that are competing bidders over the same interest. That is the very nature, the Alpha case that we cite. Two co-owners of a real estate entity. Okay, they are co-owners of the same entity, yet they are commercial adversaries because they both wanted something in the commercial business context. Even
Is
though
it
they're
different in this
co-owners.
situation when the right of first refusal, I mean, normally they have to match?
I'm sorry.
Do they have to match don't they have to match the offer? Wasn't that
They
a
have to buy
different?
it under the same terms. Is that what you mean?
So is it
Yes.
a different situation than if you have two other people that are negotiating? They don't have to match each other. They can offer different things and offer other consideration. I mean, isn't that a different situation than here where you're gonna have to match whatever the other party comes up with?
Not under New York law. The concept is, are you both going after the same thing? It's really that simple.
Aren't they
a
limited in how
commercial
they can
business
compete?
Context.
My point is, aren't they limited in how they can compete with the right of first refusal? Because you're gonna have to match whatever they come up with.
Yes, but there are numerous situations where you do have a right of first refusal and someone will up the price.
And then the right of first refusal has to up the price. And
Right.
Right.
And then it can go into a bidding war, which is frankly no different than you have two people who want something who are just competing for it.
So you're
So-
saying in that sense, they're still competitors, even though they have to match because that can just keep ratcheting up.
I'm going even further. I'm saying by the definition of two parties, one who's submitted a bid and the other one who's contemplating exercising a right of first refusal, they don't even have to actually exercise it. I'm saying when that situation is a competitive adversarial business relationship that under New York law says you two parties can't rely on each other's statements. You need to go out and do your own due diligence, ask your own questions, come up with your own things. There's a second principle under New York law that's key here. One, and it is, and they recognize they're sophisticated parties. And New York law requires them to do their own due diligence and rely on their own actions. One of the statements they claim, well, I won't get into that. They clearly have that obligation to do so, and for the fraud are not allowed to rely on our statements.
So I'm gonna jump into that pause. So why is it we're trying to figure out what New York law is when we're sitting like half a country away?
That is a great question. So let's just look at that now. And yes, this is a complicated case. When it was initially pled as a RICO case in federal court, there was something like 70 different causes of action crammed into 25 different counts. When it got repled here, there was over 50 causes of action, I think in 20 some counts. And then that got sort of spread out, and I think it ended up in like 42 separate counts.
Right.
All over, frankly, whether or not canceling a wellhead contract to a marketer is the same thing as canceling an unsigned gathering agreement to a pipeline. All of those counts, 75 causes of action, come down to that. Okay. There are tort claims, contract claims, several different contract claims. So for your specific question on New York law, that's the tort claims. Law of the injury is the rule in Kansas. We are in Kansas State Court.
Right.
When that decision was made by the parties. We looked into it, and the research that we found was that when you have a business relationship like this, and the ROFR issue is at the core of it in all of the torts, where is the harm felt? And everything we saw said the harm is felt by the plaintiff, where the plaintiff is. If the assuming it's not a counterclaim.
Yeah.
Okay. So under that law and that reasoning, all parties agreed, New York law, which was the principal place of business, and I believe incorporation, but at least the principal place of business, that New York law governed torts.
Right.
On the contract claims, got to be a little more specific there, right? There's at least 3 major contracts involved. You have the one that involves the waiver right and the right of first refusal. That's the operating agreement. Choice of selection is Kansas law. You have an unsigned gathering agreement. Choice of selection there was Oklahoma law. But even if you don't have, which gets to your question, Your Honor, about statute of frauds and why are we talking about the Oklahoma statute of frauds? Couple of things there. One, doesn't matter. Kansas law is the same. I think we cite both in our brief, our appellate briefs. If we didn't, I guarantee we cite them both in the courts below. So,
Okay. I mean, part of what, as I understood the district court's rationale, I mean, it's partly that there wasn't a contract and Oklahoma statute of frauds bars it, but it seems to me that's blending 2 issues. I mean, you have to have a contract in order for the statute of frauds to even apply.
correct.
You don't have a contract, statute of frauds just is in the books over here.
So in our,
but the rule in Kansas about formation of contracts is that, I mean, you look at you apply Kansas law, which is where the last act to complete the contract would occur, right? I mean, it's lex loci contractus, the rule as the last act. And I'm not sure it winds up with the contract. I don't know that it makes any difference. But if there's no contract, you don't get to the statute of frauds at all. If there's no objective meeting of the minds, which is one of your arguments, right? I mean,
yes, it's our third argument.
okay, well, maybe it should be your first argument.
We had a debate over that, and we wanted it to be. However, we were showing deference, trying to show deference and respect to the district court below, who made it at the end and really focus on the statute of frauds. And
I mean, it's an alternative argument, I guess, but I mean, all right.
Two separate, you're 100% correct. Both arguments, separate legal bases. One, never was a meeting of the minds, no contract period. Two, even if there was, statute of frauds bars it.
Okay. All right.
And then there's the appellate procedural issue, which is the judge painstakingly went through the rules, found that plaintiff had violated Supreme Court Rule 141, deemed the facts uncontroverted, and those uncontroverted facts require the ultimate result.
And that just relates to our standard of review.
Yeah.
And how we view the decision in finding those facts uncontroverted, correct?
Correct.
You're wrong about that, but it's what the standard of review is. But that's all right. I don't think it makes any difference.
True, and I gloss over some things. It's abuse of discretion if
Well,
they find it's a penalty.
I disagree. I don't think it is a use of discretion standard. I mean, I understand there's a recent opinion from our court that says that, but it misreads Rubke. I don't think Rubke says it's a abuse of discretion standard at all.
Well, I don't think Group Key is the only case on there, but at the same time,
Well, it's the only one that the Court of Appeals cites. But I don't think it makes any difference. It doesn't come out, I mean, it comes out the same place anyway, but that's not, I don't think that's the standard.
true, and it does come out same place, so I'll just say the Court of Appeals actually cites two other Courts of Appeals cases. And one begins with an S and one begins with a B, and I'm sorry, I don't have the names on top
Are
of
those
my head.
unpublished ones?
Yeah.
Okay.
Yeah.
Can we talk about meeting of the minds on whether there was a meeting of the minds on the gathering agreement?
Yes,
I would like to know your position on what material terms remained outstanding. I understand it was the well connection costs, the reimbursement for that, is that correct?
that's one of them, yes.
And was there an issue with the minimum throughput as
Yes.
well? Anything else?
Yeah, most importantly, I would argue, is EFP's own acknowledgement at the end that if Stevens isn't happy with the pricing, that's something that we could always change. So please go ahead and sign the thing. Okay? Pricing is a pretty fundamental term. And it's clear from the record, and there's nothing that says pricing for all time is guaranteed. Two other things, if I may, just I need to get this out. One, this is a situation where one party, the evidence is clear, refused to sign. We have not found a case anywhere, any jurisdiction that has enforced an unsigned contract against a party who has expressly refused to sign. Two, I realize this is a de novo review. So don't take my word for it and don't take the district court's word for it. Look at the actual evidence. I implore you. Go through the emails. We tried to line them out in chronological order so that someone could just read through a summary, but don't read our summary. Pull out the actual emails. Look at the evidence. There is no way you can look at all of the questions that are going back and everything else and come to a decision that there was a meeting of the minds here. To Judge's point, our first argument probably should have been no agreement, period.
So the material terms you claim that were outstanding were the well connection costs, the throughput, and then this pricing based on EFP's offer to Stevens.
And
Pricing, anything else?
yes, dedication. Okay, two very vitally important things there. One is just the fact Canyon Midstream, a party that they were trying to work with, sends dedication language for them to try to incorporate into the unsigned, unfinished, unnegotiated, uncompleted, non-binding gathering agreement on, I believe it was September 16. So pretty late in the game. Closing was supposed to be the 18th, 2 days later. Second, don't forget what the evidence shows, okay? There is one term that matters in the unsigned gathering agreement. It's a 10-year dedication of acreage. Because every well you drill in this acreage goes to this pipeline. Everyone. Okay, that's the term. Since September of 2013, parties not one day operated under that dedication. Why? Because there are wells in there that don't go to Namaha Pipeline.
Were
They're
those-
connected to other pipelines.
And weren't they already under contract for those pipelines before the NASB, is that correct? Are those the ones that the NASB contract that says, hey, we're accepting these because they were under contracts beforehand? Or are those separate wells?
I believe that those are separate wells. But I think, okay, so there's 8 total wells. There's
Right.
32 wells total, okay? I'm talking about 8 of them go to a different
Right.
pipeline company.
Mhm.
Some of those 8, I believe, are exactly what your honor is talking about. I'm gonna get the numbers wrong. I think maybe 3 of them. But the rest, however many that numbers are, weren't part of that specific thing. The fact is that they were better situated to take the gas. And so EFP worked through them, not Namaha. So if you're going to try to say, one, as a matter of law, part performance doesn't get you out of the statute of frauds, even if they were performing under this dedication. 2, as a matter of fact, it is impossible to find that they were operating under this dedication as if it was a valid dedication. They just simply did not take all the gas to Namaha Pipeline, period. There was no binding agreement. And with respect to this, sort of brings in the fraud argument a little bit, but I have to make this point because it seemed to getting lost when we're talking about some of the other merits and frankly, some of the issues that aren't one of the 7 rulings we're talking about here today. Don't forget, everybody told them there was no dedication. It's not as if, I mean, counsel made a statement, which I have to take exception to. He said strategic was told there was, quote, no issue, we have an agreement, close quote. No, no, no. Absolutely 100% false. Strategic was never told that by anybody on the other side of the V. Never told that by any of the third parties they tried to market it to. Slauson told them point blank, we're a year into a 10-year dedication to EFP for marketing and administration. Next sentence, but the gathering agreement hasn't been addressed. We still have minimum throughput issues.
I'm quoting you, you're right on page 14 of your brief, but we have not finished the gathering agreements, including minimum throughput commitments. Is it understood that that 1 year into the 10-year dedication was to EFP? It's understood, correct?
Yes.
So there could
That's
be
a
no
yes.
misunderstanding of that statement that you just
Zero.
read.
What do we do with the July 14th Lawson email to Stevens that says, hey, EFP and Nemaha are prepared to sign this gathering agreement? They mentioned in their argument and mentioned in the briefs as well.
Yep. So 1, he didn't sign, right? At that time, they had already agreed, we had already agreed to buy the pipeline, we being Stevens. They had tried to finish up the negotiations as best they could and send it over to us and said, okay, you know, if you guys want it, we're pretty much, the general counsel was saying, we're pretty much done. Okay. Pretty much from that point forward, they deferred to us. Earlier in June, and I think it's that same I think it's earlier in that paragraph that you just quoted, but same email from Steve Slauson, where he says, although that may not be right. Anyhow, Steve Slauson says, get your contract people involved. Okay. Because they were turning over the ultimate authority to us because we were the ones buying the pipeline. We're going to have to live with it. So yeah, at one point in time, Slauson said, okay, this one's up to you. Least there be any doubt, September September 4, okay, 3-4 months later, my math is bad. EFP is still pressing to get this thing signed and reaches out to Steve Slauson again. Hey, sign the dang thing. And Steve says, no, we're not signing it. It's going to have to be the new owners. That was us. And we told Slauson, hey, don't sign this close to closing. We've got our hands full with these wells and trying to figure that out. We're going to get to this pipeline stuff later, but we don't like the pricing at all. And this whole pipeline gas marketing thing, we have serious concerns about. It's done under a NASB, which is National Association. Anyhow, it's a spot sale contract. It's not supposed to be a wellhead sales contract. Ann Weber is a very esteemed lawyer who was involved from Denver, who resigned over the fact that they were using the NASB, and she couldn't get EFP to change it. We saw those things. We didn't like it. We wanted to cancel that. But
I guess I'm concerned that there is a fact question between what Slauson agreed to and maybe what Stevens would have agreed to, because I'm wondering why we can't interpret the evidence, including the July 14 email that, hey, we're all ready to sign. Here, Stevens, this is ready to go. Or even the EFP pricing comment that you mentioned where EFP is saying, hey, I know we've got these price terms in the agreement, but if you want a new agreement, basically, Stevens, we're ready to negotiate it. Why doesn't the evidence support an inference that Slauson had an agreement, but maybe Stevens wanted a new one? And so we're not signing because Stevens is coming in and they want to renegotiate the terms because they don't like the pricing terms and they want to change things. But just because Stevens doesn't agree, I guess that's what I'm struggling with is why does that mean Slauson hadn't already agreed?
two things. One, Slauson refused to sign, as you mentioned. But
Because it was getting ready to sell.
Right.
Okay.
And it didn't feel like it would be proper for it to finalize and create a binding agreement. Second, Stu Kowalski not only sent that email, he also provided deposition testimony that opposing counsel referenced, right, when he was talking about the MIPA. And what did he say about the MIPA? He said, and that was the contract that listed as a material contract and uses the word unsigned by it, the red flag word unsigned by it. What did he say? This is the uncontroverted testimony of the author who wrote it. Yeah, it would be material. We felt that we needed to disclose it to the buyer. Okay. Counsel raised a question. Why would you have to do it if it's not a binding contract? Pretend for a minute you are buying a pipeline. You are going to own the pipeline. Would you be interested in knowing whether there were negotiations to commit a bunch of wells to your pipeline? Would that be something you would care about if you were going to purchase that asset? Even more so, if there were negotiations, would you want to know the current status of them? And maybe an unsigned contract. Plaintiff is asking, and so that's exactly what Stuart Kowalski testifies to. His testimony, uncontroverted, is that there is no contract. There's no signed binding agreement, which is also supported by Canyon Midstream, who provides Strategic a legal opinion saying there's no binding dedication because there's no signed contract. It's supported by their own employees who are communicating with Canyon, who are looking at this and saying, oh, this is month to month because there's no signed, all we have are drafts. We don't have a signed contract. Everybody in the industry looking at this sees it's unsigned and says, oh, there's no contract. Don't take my word for it. That's what Tolo came up with. That's what Enable came up with. Every single entity involved, third party or party to this case who looked at it, came to that conclusion, save one, Doug Walsh at US Energy. And he said he relied 100% on the opinion of his lawyer. That's it. Didn't rely on anybody else saying anything that there was a dedication.
What's the interplay between the NASB and the gas gathering agreement and the dedication in each of those?
So Slauson contracts with EFP, which has experience as a marketer. And so they're supposed to move the gas. and get a better price for it. Stevens had already been operating other wells in the area, made it a logical buyer for, because they had synergies. They were familiar with a lot of different gas options and markets that they could take gas to. Okay, so they didn't like the fact that they had to go through EFP because they could do it themselves. Plus, EFP was getting a lot lower price than what they were getting. So they have a little bit of a problem. They have to be a reasonably prudent operator of the well. And if not, they face royalty claims. So they don't like that contract, not to mention it's a NASB form, which is like trying to jam a square peg through a round hole, and gets this, esteemed lawyer to withdraw because she's so offended by it. So the interplay is from Slauson's perspective, and that's all what Stevens saw and what Stevens wanted. Slauson sets it up to work with EFP and lets EFP market the gas. But EFP has the ability to contract with Namaha, which frankly Slauson was egging for because they like that because they're part owners through Alameda of that. So that helps them out too. They did not own the third party of the two other third party pipelines. Okay. So they have no financial incentive for EFP to take it that way. They aren't going to get any piece of the transportation revenue. But EFP has, other than being a marketing agent and literally being our agent through an agency letter, our agent, Slauson's agent, they are not constrained. They can go to any pipeline they want. Slauson obviously pushing them towards Namaha. They obviously engage in negotiations with Namaha, but then Slauson started pushing back on well connect costs, minimum throughput, and some other issues. And then they never consummated that deal. As Judge, as you pointed out, the original dedication is a term of convenience that allows opposing party to use one term to address two separate things. Okay. This is why the unsigned gathering agreement is a dispositive issue. Regardless of whether we cancel the NASB, if there's no dedication to the pipeline, okay, then canceling the NASB doesn't change that. Can't change that. There's still no dedication. No dedication before, no dedication after. No change, no claim. None of the 75 causes of action. Original 75 causes of action. So the only caveat is something that my co-counsel will address if they're allowed to do an about face on their theory of the case and say, oh, there wasn't a dedication, change the facts, now we're coming after you for not getting dedication. But short of them allowing that to be added to the pretrial order, not one of their pleadings, this issue of the unsigned gathering agreement, 100% dispositive, all claims in the case. Now, if I could pivot to a question that came up earlier about damages and an accounting claim and things of that nature. Those are also, well, not those. The damage claim is 100% dispositive of the case. What I believe is in the record is the district court's opinion that even the deposit is wrapped up as part of the damage theory. But there was still an issue, which I don't believe is before the court in the appellate record, about that and about the accounting claims and about some other, I will call them miscellaneous claims that were still in the case after we got these relatively dispositive issues. Council got together and got rid of those claims. And that's not part of the record because it wasn't one of the 7 issues that, not part of the appellate record, let me be clear, because it wasn't part of the 7 issues that came up. My understanding, and honestly, I don't even recall all the details, but that we agreed and went through everything and said, okay, these are the dispositive issues, and created the record at the court below for that. So let me be clear. 3 of the 7 issues that the court has before it are dispositive. with an asterisk by the unsigned gathering agreement based upon the claim that Slauson breached its duty not to get the dedication. That's one, damage is the other, mitigation is the third.
Before we went to talk about mitigation, but what are we supposed to do with this thing that's not in the record that supposedly takes care of the $500,000 earnest money that, I mean, it's in the pretrial order as a claim, if I recall correctly, and it's a separate and distinct claim. I mean, and the expert has nothing to do with that. I mean, the damages thing is striking the expert's testimony.
Part of the damage amount is the $500,000.
Yeah,
But setting that aside, procedurally, my recommendation would be just rule on the issues before you and send it back.
Then remand it
Mhm.
for further proceedings.
okay.
I briefly think all of this was journalized in a final order, making these issues appealable. I believe that order is in the record. If it's not, we can supply it. If it is in the record, we'll tell you where it is.
We don't really have a final order disposing of all claims in
Yes.
this case?
We do. That's what I'm
Because the
saying.
judge has certified it. No, right, on two
It,
fifty-four.
it is a final order. It's not a 54B.
All right,
Yeah, no, it's.
well,
And,
we ought to have that
and
someplace.
I'm sure that's in the record and we'll give you a site for it. And we negotiated and frankly, plaintiff's counsel, they thought about the $500,000 deposit issue and said, no, that is part of our damage. And the judge in his damage order specifically said, the 500,000 is folded into their damage because they had already paid it and it would be credited against the purchase price. And arguably plaintiffs could have still pursued that separately. They chose not to do that.
All right,
And that's
well,
folded into the final
We
order.
probably need to get our hands on that order.
We'll get that.
You're saying, your recollection is that's not in the appellate record?
My recollection was it wasn't in the appellate record, but his
I-
recollection
I
is that
believe
it
Guess
is.
what date that was?
Would be,
It would have been in
Are we looking at July 2022?
22, I think.
Okay, I think,
we'll either find it, if it's not there, we have the authority to ask that it be added, and I mean, I think we
Yes.
may, well, I can't speak for my colleagues, we probably want to see that.
We can do that.
All right, well, or we can do it too, but, all right,
Whatever the court's desire.
yeah.
All right, cross appeal.
Yes, sir. Or your honor. Like I've said, the case comes down to whether or not there was a dedication to the pipeline. Okay? Had to be through the unsigned gathering agreement. However, the mitigation rule issue is really very simple. The entity through which strategic functions, because it has no employees. That's why everything you see, all the emails come from US Energy personnel, could dedicate 30% of its own gas. If it does, you have the only testimony in the record says the others have no viable option. The only response to that, the judge said, well, you know, it's a little too far. Respectfully, this is the one issue where I think Judge Comer got it wrong. Because 100% of the evidence supports this conclusion. Now, he does say in his order, this is going to be a bench trial. Unless they come up with something better, I'm probably going to be persuaded by it. Respectfully, the time for them to come up with something better, an affidavit, it's even a self-serving one, something, anything to contradict this evidence, was during the summary judgment briefing. They had the opportunity, full-fledged, didn't do it. Now, who are these three individuals? Okay. Steve Slauson, Todd Slauson, and Mike Callan. No surprise, Steve and Todd are the decision makers for Slauson, who is the operator of the well. Mike Callan is a decision maker for Stevens, who was going to be the operator of the well, and now is the operator of all the wells. These are individuals not only experienced in the industry, okay, which they unquestionably are. We asked these people, what were you gonna do with your gas? Your gas, not someone else's gas, your gas. Because not only did they own 45% of it, they're the operator. So unless somebody else comes in and says, I want to take my own gas, like US Energy had the right to do, they had the obligation to sell that gas too, and to transport that gas too. Strategic's argument is, well, that's a hypothetical. It didn't actually happen. Of course it didn't happen. This is a mitigation of damages issue. By definition, every mitigation claim is about something that didn't, but should have happened. If you say, oh, well, it's just hypothetical, it didn't actually happen, so we don't actually know. You might as well say, in Kansas, we don't accept mitigation. Period. It's always based on that. So in this context, ask yourself, well, okay, they say it's clear, they don't deny that they could have easily dedicated 30% of the gas. No question about that. So from a mitigation perspective, what sort of evidence would you need to convince yourself that, yeah, that effectively is 100% dedication? I submit we gave you the 3 decision makers that are the most relevant people on the face of the earth to give you that testimony and to give their opinions. And that is, yeah, our hands would have been tied. We know the market. There weren't other options. No one was going to come in, even the other third parties, to only get a portion of gas. Remember, these are oil wells. Gas is a byproduct. They're primarily, it's just, you know, it's a fraction of what you would get like from a gas well. It's not even a fraction, it's less than a fraction. The old Hugoton field, for example, totally different situation. This is an oil play. So this is a byproduct. Companies are not going to build out to a pipeline. There is zero evidence in the record, zero, none, zip, zero, zilch, of anything other than there's no way in the world they would have had another option. Since that is what the undisputed facts show, frankly, there's no question of fact. This is de novo review. It's the one issue you should flip. Respectfully, I would submit the court first look at damages. If you rule in favor of defendants there, you can stop. If not, go to this mitigation issue on the cross appeal. If you rule in favor of defendants there, you can stop. If not, go to the unsigned gathering agreement. If you rule in favor of defendants there, you can almost stop. You got to check the pretrial order and whether or not you'll allow that. And with that, I'll turn it over to my counsel for Slauson and Alameda, who can tell you about that issue. Thank you for your time.
Thank you.
May it please the court. I'll try to be as brief as I can because I know we're into the noon hour. On the damage issue, the district court properly granted summary judgment on that claim, or it's actually an issue because as we've talked about already, the damages are overarching over all of the separate claims for contract and tort claims. And as Mr. Salzman just said, if you start with a damage issue and you affirm that, we're done. There aren't any straggler issues. The accounting claims are gone. The $500,000 deposit issue is gone, and we'll get that to you. But that, to us, that is the straightforward way to handle the case. And what the district court did is he looked at what plaintiff's expert said and reported and valued the pipeline at, and he concluded that he had ignored the actual facts of the case and relied upon for value a projection of the number of wells that was a complete fiction. And I think we've briefed this adequately, but it's clear in the record, and none of this is disputed, that at the time Stevens was considering buying both the wells and leases and the pipeline, it came up with a drilling plan. And in that drilling plan, there were going to be a total of 140 wells. Well, when Strategic got into the mix and was considering exercising its ROFR, they came up with a drilling plan that was more than twice as many wells, 320 wells. Now, they weren't going to be the operator. Stevens was going to be the operator. And Stevens came up and Stevens would have had both the responsibility and the economic interest to fully develop that field. And they intended to do so. And they were going to drill 140 wells. Well, Strategic's model came up again with the 320 well, and they try to justify that in an affidavit and in some of their testimony. But the point is, in looking at this pipeline and whether a buyer would want to buy that pipeline, who's the buyer going to rely upon? And on page 4, I believe it is, yeah, of their reply brief, which we didn't get a chance to respond to, Strategic claims that we had no support in the record for what a willing buyer would do when buying a pipeline. That is flat wrong. We cited the testimony of Mr. Carlos Evans, who was the chief commercial officer of Tall Oak. And as you know, Tall Oak looked very hard at the pipeline in 2015. He testified that he and of course, neither he nor his company had any economic interest in this case at all. They were completely neutral. He testified that when looking to buy a pipeline asset, he would go to the operator of the wells that are feeding that pipeline and find out what their drilling plans were. Doug Walsh, we also cited his testimony. Doug Walsh, I don't know if we've mentioned his name today. He was a senior executive at U.S. Energy, Strategic's managing partner, and thus he was a key witness for Strategic. He said in his deposition that if he were buying a pipeline asset, he would talk to the operator about how many wells, what they're, and the wells, of course, generate the volume of throughput for the pipeline, which affects the value of the pipeline. So if he were looking to buy a pipeline, he would go to the operator of the wells and find out.
That all go though to the weight rather than the admissibility of Hardin's expert testimony. I mean, you're not challenging his qualifications.
Not challenging his qualifications, I agree, but an expert cannot ignore the actual facts of the case and rely on a theory that is untested in the market. And this is why it really comes down to it's not a fact issue, or as you say, it doesn't go to the weight of the evidence between the opinion of the operator of the well and the opinion of a hired expert. That's not the issue. The issue is what would a willing buyer look at and rely upon in evaluating what to pay for a pipeline. And of course, the second reason that the district court properly granted this part of the summary judgment motions was they didn't have a buyer. What's the evidence in the record of what buyers would do? They can't come in with testimony from a potential buyer and say, oh, I would have relied on your model of 320 wells. There's no evidence.
What do we do with their argument that you frustrated their attempts to find that buyer by canceling certain contracts? And so that's why they couldn't produce the buyer in that situation.
That is unsupported in the record. And I have that in my notes, but they say in their reply brief, the record is clear that we couldn't find a buyer because there was no dedication. That's not clear at all. What the record really supports is they couldn't find a buyer because from the very beginning, they had an inflated view of the value of this pipeline.
But it
wasn't supported in the market.
But isn't that, I mean, the issue is what the fair market value is.
Correct.
Right? Okay, it doesn't really matter whether there's somebody standing in the wings who will say, I will pay that. It's whether there is a reasonable estimate of the fair market value. You're saying that Hardin or the district court was correct in saying Hardin was completely unreasonable.
Yes. I mean, what the district court said is you can't rely on the 312 marketing model to the exclusion of the actual facts of what the operator was going to drill.
Right.
That's what he said. But another point is they didn't have a buyer, but there was a fair market value established for this very interest in the pipeline.
That's the Stevens Alameda deal under the MIPA. Stevens agreed to pay 10 point something $million for a controlling 51% interest in the pipeline. You do the high school math, as the district judge said, you do that, that sets a value on the pipeline of $19.9 million. That was a negotiated, and I'll address whether that's an arm's length sale in a moment. Clearly was, but that's negotiated. This is after Slauson and Alameda have tried marketing both the leases and the pipeline for months, at least 6 or 9 months, I believe. And the bid they got, the high bid, was from Stevens. And for the pipeline part of it, it was approximately between 10 and $11 million. That equates to a value of nearly 20 million for the pipeline. And if you're going to overcome that fair market value contract, it was a contract, and you're going to claim that the pipeline is really valued at 47 million, more than 2.5 times what the market showed it was valued at, you better have a buyer, or you better have at least a potential buyer who will come in and testify. It was not the lack of a dedication. All of the discussions with Tall Oak, for example, in the summer of 2015, and of course, Stevens and Slauson agreed to let Strategic continue to try to market the pipeline, see if they could make a profit. All of the negotiations with Tall Oak were based upon and assumed 10-year dedication from Stevens directly to the pipeline. Well, Tall Oak obviously didn't buy the pipeline. They finally, when they figured out what Stevens actually was going to drill, their offer was only $12 million for the whole pipeline. That would have generated U.S. Energy, or Strategic, excuse me, no profit whatsoever. In fact, they'd have lost $8 million.
They ought to be paying you.
There's been some talk about that on our side of the table.
I think that's mentioned in your brief that they benefit.
We obviously did the math that for them to generate any profit, the pipeline had to be worth a lot more, because they already had, I think, $9.5 million in it. And had they exercised the ROFR and actually bought the pipeline at the time they wanted to, they would have had about $20.5 million in the pipeline. So they would have had to get more than that to make any profit at all. And of course, Mr. Hardin comes up with 47 million, relying on the 320 well situation. Let me address briefly, because I know I'm running out of time, the idea, the Strategic's basic attack on all of the fair market value evidence is to say, well, you can't rely on the MIPA price of $11 million, which values the pipeline at 19.9 million. You can't rely on that because Stevens wasn't a willing purchaser. They didn't want the pipeline. I'm sorry, but people do things all the time that they don't really want to do. They may feel like they have to do it. In this situation, the evidence is crystal clear that Stevens wanted to purchase the wells and the leases. They thought it was a good field. They already had wells in the field. They thought it would be good synergy for their business. They didn't really want the pipeline, but Slauson was offering it as a package deal. And the fact that they were less than enthusiastic about buying it doesn't mean they didn't bargain directly with Slauson and Alameda and came to a value of the pipeline that reflected 100% of the pipeline was valued at basically $20 million. There is no evidence in the record anywhere that that's not fair market value at this time period. And the issue of them not having a buyer at that time, it's even more critical. And I think this came out earlier, maybe in questions to Mr. Perry. They didn't have a buyer on September 17, which is that's the date they say their damages were incurred. They don't want to look at anything that happened after that because they don't want to recognize that the market tanked 3 months later. But they didn't have a buyer then. They didn't have a buyer 2 months later. They didn't have a buyer in the middle of 2015. Again, because they had overvalued the pipeline.
And in this situation, we think, and this is essentially what Judge Comer ruled, is that when you've got direct evidence of value between Stevens and Alameda valuing the pipeline, if you're going to claim it was really worth $47 million, you better have a buyer. And they didn't. And the other aspect, I think, that I should mention, in fact, I think Judge Klein referenced this. They claim that when they were going back to the expert, they claim, well, he really did consider what Stevens was going to do with the field, because he looked at the how many rigs they were going to be running at certain periods of time. It's not the rigs, it's the number of wells that are ultimately going to be drilled. And he admitted in his deposition, it's all over the record, I never looked at that. They didn't give me that. Well, at the time they did their 320 well model to market the pipeline, they knew that Stevens' drilling plan was way less than that. They absolutely knew it, and they just ignored it, and they didn't provide it to their expert.
Does it matter that strategic valued the Woodford Shale and Stevens didn't? I mean, doesn't that kind of impact the number of wells the operator would intend to drill if we have different valuations on the plays out there?
It did. But again, you go back to what would a willing buyer be looking at in trying to make a decision to buy Nemaha Pipeline? Would that buyer, and again, the testimony is undisputed in the record from Carlos Evans, from Doug Walsh, from Hardin himself. Their expert admitted that he'd want to know what the operator of the wells was actually going to do. And if the operator of the wells, in this case Stevens, said, we're not going to drill in the Woodford, well, you wouldn't fold that into your estimation of how much to offer for the pipeline, because Stevens is the decision maker on whether to drill in the Woodford or not. And if they think the geology doesn't tell them that that's going to be profitable, then they're not going to drill there. It's not going to generate any gas to go through your pipeline and generate tariff money. And so again, go back to what's the evidence in the record that Judge Comer found uncontroverted, and frankly, regardless of the standard of review, his opinion is meticulous in finding there's no controversion of this evidence, there's no controversion of this, and he did a very good job of that. And when you come down, the other thing I should say, because this came up, they said in their brief, well, but you can't criticize the expert because in the work and whether he realized the actual facts and whether he ignored stuff. You didn't, without challenging him on a Daubert motion. We did challenge him on a Daubert motion, and that's in the record. And it makes exactly the same arguments that our summary judgment motion made. District court simply chose to address those issues as a part of summary judgment instead of doing the motion to exclude first. They'd be in the same place. If he'd looked at the motion to exclude Hardin's opinions and granted that for the same reasons that he granted summary judgment, then they'd be left with no evidence of damage. And we'd be right back at where we started. Let me talk very briefly about the motion to amend the pretrial order. And we've talked briefly. It had two parts of it. The shortest part was they tried to add an alter ego claim and tried to treat Slauson and Alameda as the same entity. Well, they're not. And they didn't have any trouble in all of these business dealings with knowing that they were two separate entities. And it's not a parent subsidiary situation at all. Slauson Exploration is a freestanding corporation. The founder of that, Donald C. Slauson, created a trust, and that's the Alameda Oilfield Services Trust. And basically, the service businesses were held in that, which this pipeline was, their interest in the pipeline was one of those. But from the very beginning, the very first pleading filed in the case, Strategic didn't have any problem pleading separate claims against Slauson and separate claims against Alameda. Lots and lots and lots of separate claims against each. When they entered into the pipeline agreement, Strategic didn't say, well, wait a minute, why is Alameda the 51% interest owner and not Slauson? They knew the difference between them. And so they come in years and years and years later after the pretrial order has been entered and try to amend and add a claim. But the key part of the ruling denying that, insofar as the alter ego issue, Strategic made no showing of how they were damaged by treating the two as separate entities. And that's that's the key factor in an alter ego analysis is, well, how have you been damaged by having the two different entities instead of treating them as one? And they didn't even attempt to make a showing about that. The other aspect of the amendment was to add a claim that Slauson breached its professional duty as an operator of the pipeline by failing to get a dedication. And it's apparent from all the discussion we've had today in the last couple of hours, that's totally inconsistent with their claim, what their claim had been the entire lawsuit. Their claim was there was a dedication, and by canceling the NASB, you vitiated that dedication and devalued the pipeline. And now they want to come in and say, whoa, oh, now we agree there was never a dedication and you breached our duty by not getting one. And the judge, I think the primary reason the judge denied that and properly denied it is they knew from the beginning that we didn't think there was a dedication. Slauson told them, Stevens told them, Canyon Midstream told them, all in the year 2014. But they had it in their head that they had a dedication and went right on down that road. They can't come in 8 years later and change all that, change their theory of the case. How would you go try that lawsuit? Well, we're going to first try whether there was a dedication that you canceled, and then we'll turn around and try, oh, no, there was no dedication. Judge Commer saw through that and saw that that was improper. You know, he basically denied that on all the ordinary grounds, undue delay, prejudice, those things. And the other aspect, which I think was absolutely correct as well, is they couldn't establish this claim without an expert. Who's going to say that it's the pipeline operator's duty to get a dedication to the pipeline? And did everything that Slauson did over a year and a half in trying to get the gas gathering agreement finalized and get favorable terms in there, was that enough to fulfill that duty? And even if Strategic didn't have an expert, Slauson would have had an absolute duty to call one to explain to the jury how all this works, what operators do, what their duties are, and whether or not what they had done was sufficient. So again, that's clear. Your standard review on that is clearly abuse of discretion, and Judge Commer did not abuse his discretion on that.
Thank you.
Thank you.
5 minutes left for rebuttal. You want to use it?
We'll use the real 5 minutes.
Yep.
And so to get going on the summary judgment issues, this body is well aware. The issue is there no reasonable construction of the evidence that would permit the jury or fact finder to award a verdict in favor of the plaintiff? And I submit upon this court's review of the summary judgment record of the 3 summary judgment issues that the only conclusion to draw, once one reads those, gives the inferences that are reasonably drawn from the evidence submitted in response to summary judgment, that we have questions of fact. And with all due respect to Judge Commer, I have this on the table for a reason. This stack of notebooks is just the plaintiff's exhibits in response to summary judgment. I know, I'm sure he was frustrated that there's a lot of issues, there's lots of contracts, there's lots of emails, there were tons of claims. I'm sure he had a whole lot to examine. But to suggest that the summary judgment briefing rules were not complied with, I respectfully submit is wholly without basis. Everything that is cited in the response goes to a specific bit of facts that's supported by evidence that's in the record. And when the inferences are drawn most favorable to the responding party, there's clearly issues of fact on these issues. I don't want to belabor the two that we've talked about mostly, but I'm going to comment on the mitigation claim. First of all, mitigation would apply to Strategic. Strategic does not own a single leasehold interest at issue. Strategic could not have dedicated a single thing to the pipeline because it did not own oil and gas interest. What our esteemed colleagues on the other side of the table want to do is impute that obligation to U.S. Energy. Well, U.S. Energy does not have an obligation to mitigate. The duty to mitigate would rest with Strategic, and the record is clear, and there is affidavit testimony in that motion in responding showing U.S. Strategic does not have that any leasehold interest to convey. Second, and this is rank with respect to the mitigation, it's rank speculation by the defendants to suggest if U.S. Energy would have done so, meaning dedicated their interest directly to Nemaha Gas for 10 years, that the other parties would have done it for 10 years. How does that flow? That's rank speculation. The reality is you had an existing agreement in place for 10 years, and it was a structure that Slauson set up. The 10-year NASB with the 10-year gas gathering agreement. They couldn't just have willy-nilly walked away from that and said, we're gonna breach that agreement and give our gas directly to the pipeline. That makes zero sense.
Got 1 minute left.
Okay, on the unsigned gas gathering agreement, Judge Pickering, I think, asked something a long time ago about we were discussing material contracts, and we went over the language in 4.18. If this was an issue that, as Mr. Kowalski said in September of 2021, that we're only doing this as a favor, they could have put that in a section called contingent liabilities. They didn't. They put it as a material contract, one that the clear language of that agreement says they were a party to and bound to. If that doesn't create an issue of fact, I don't know what does on that particular issue. On the
About 10 seconds left.
okay, on the jury waiver, I direct the court to the Schwab case from 2022, which clearly points out that the Supreme Court first has to look at the issue of, are we even going to exercise our discretionary power? Then they decide if mandamus is appropriate before they take it up on the merits. There's no indication in this record that they ever did anything beyond the first thing. Thank you. And we appreciate, and I think I can speak on behalf of everybody, that we really appreciate the time and effort that you all have put into this. It's clear from your questioning that you really have invested a lot, and we all appreciate that. So
I
thank
think we
you.
set a new record for me for oral argument.
The final order is in the record at volume 8, page 279.
8279.
8279.
Thank you.
Thank you.
Average wrong.